Chief Justices, Your Honours, distinguished guests, ladies and gentlemen. On behalf of the Law Institute of Victoria and the Victorian Bar, can I welcome you all here today to this marvellous event. Today is a great celebration of the collaboration in our profession. The Bar, the LIV, many of the major and smaller law firms, the Court and many of in-house counsel have gathered together to put this great conference on. The topics are as diverse as the overarching ethical obligations to the collision between public relations and the law, bushfires and class action litigation, and international arbitration. Our speakers include the State Attorney General, our Chief Justice of the Victorian Supreme Court, the Chief Justice of the Federal Court, Justices Judd, Forrest and Croft from the Supreme Court, Justices Middleton and Gordon of the Federal Court. Solicitors from most of the major law firms have also gathered, have a number of the regulators and officials from the ACCC, ASIC and the Australian Government solicitors. Many of our leading silks will be speaking today. It is a great celebration of our bar, our profession and the LIV in times when we're matching cost-effective litigation with our increasing overarching ethical obligations. We certainly hope you enjoy today. We thank you very much for attending. I'll now hand over to the President of the Law Institute of Victoria, Geoff Bowyer.
Thank you, Will. You've done an outstanding job in assisting the Law Institute of Victoria and the Bar in pulling this great conference together. And can I thank all those who have worked so hard to organise today's conference. Putting a conference like this together has been a wonderful combined effort, and it enshrines the values of the Bar and the Law Institute of Victoria in representing lawyers in the state. I would also like to thank all speakers and panellists for their time, input, and for the considerable distance some have travelled to be here today, in particular Peter Meegans from Kingwood Mallison, Singapore. Our mission was always to stage an inclusive conference that involved all branches of the profession. I think participants will benefit greatly from hearing from the different perspective of all speakers and those on the panels, from the judiciary, the bar and the legal practitioners from many of our leading firms. The themes of today range across all forms of litigation, arbitration, mediation, enforcement, regulation and costs. As a profession, we are grappling with the demands from our clients that we handle their commercial disputes more efficiently and cost effectively and represent true valuable service. The rising cost of litigation is a common theme when I'm talking to members and my clients. In my term as President, and indeed in my time on LIV Council, we've focused on the imperative to resolve disputes wherever possible by alternative dispute resolution processes. I know this is a goal we have in common with the state government, the judiciary and the Victorian Bar. And it is to this end that we in March this year launched the Melbourne Commercial Arbitration and Mediation Centre with Victorian Attorney General Robert Clark and Chief Justice Marilyn Warren. The centre, which is based at the William Cooper Justice Centre, sets the standard for commercial arbitration in Victoria and across the region and gives parties access to purpose-built facilities and high-quality arbitrators and mediators. Court Services Victoria provides general and booking information, and if you haven't already, I encourage you to check out their website, which is www.mcamh.com.au. I would also like to mention that the LIV's International Law section will hold the grand final of its inaugural International Commercial Arbitration Moot at MCAM on 27 November 2014. The moot provides an opportunity for students, law graduates and young legal practitioners to exercise and improve their advocacy skills in an international arbitration. We are very excited to see it take off, and we hope it will lead to a national competition in the coming years. I would like to encourage your younger practitioners to register for the moot. Registrations are open until the 28th of October, and further details are available on the LIV website. Finally, just a couple of housekeeping matters. Today's proceedings are being recorded, So I urge you to turn your devices to silent, and I'll hand back to Will to introduce you to two keynote speakers. So let's have a great day. Thank you.
Ladies and gentlemen, can I now move on to introducing our two keynote speakers and ask both the Honourable Chief Justice Marilyn Warren and the Honourable Chief Justice Allsop to come up to the stage, please. It's our great pleasure today to have two such distinguished keynote speakers giving a judicial perspective on current developments and challenges in conducting litigation in the Supreme Court and the Federal Court. Chief Justice Warren and Chief Justice Allsop need no great introduction. They are both well known and their reputations precede them. They are, without doubt, highly distinguished and true leaders of our profession. Chief Justice Marilyn Warren was the first female Chief Justice in Australia of the Supreme Court. She celebrated recently her 10 years in office, and on behalf of the bar and the whole profession, we have a number of times congratulated her on an extremely great job in her role, both in leading the court but also leading our profession. I know the LIV and the bar have had the great opportunity of support from Chief Justice on many occasions in all developments of our profession. It's my great honour now to call upon Chief Justice Marilyn Warren.
Well, thank you, Chairman. Chief Justice Allsop, Your Honours, Chairman, President, ladies and gentlemen. It is quite an extraordinary event as I look across this room after nearly 40 years in practice, one way or another, to see this collaboration occur. Collaboration will be a theme which will resonate through my remarks this morning. I hope at the end it will resonate with you. If you reflect upon it, Chief Justice Allsop and I represent the vast bulk of civil litigation in this country. The Supreme Court of Victoria is the second largest and busiest civil superior court in the country, and the Federal Court covers the federal jurisdictions. Together, it is quite an amalgamation this morning. The purpose of this morning at the outset is to give you a snapshot of just what is about to happen and give you a forecast of things that will affect you in your work as litigators. In the Supreme Court of Victoria, we now have a mega trial courtroom and also other electronic court facilities in the main building. This has proved to be very important and will become more clear this afternoon when Justice Jack Forrest speaks to you, particularly about the experience of the Kilmore East bushfire trial. It was a case where technology of a leading edge quality was utilised. We in the court made sure that the judge was not left alone as an isolated individual to be the subject of a tsunami by counsel and solicitors with all the information and issues to be determined, and then have to walk away and try to write a judgment. This is, in the modern world, an impossible challenge. So what we did in the Supreme Court was provide extensive IT and other research resources to support the judge. If you look at the Supreme Court website, you will see the lone judge, Justice Forrest, and for those of you who know him, he's not a man of huge stature, and there he is, the small, isolated individual on the bench, but in front of him there was a wide row of individuals who constituted the support being given to his honour. On the other side, of course, there was a phalanx of counsel and lawyers all preparing and marching into battle. An interesting aspect of the Kilmore-East bushfire trial was that His Honour very courageously issued an edict banning trolleys. He also banned folders. I have seen some photographs where one or two senior counsel managed to sneak a folder in, but on the whole it was a paper-free trial that ran for almost a year. This was an extraordinary achievement. One of the other learnings that came out of the Kilmore-East bushfire trial was the way in which technology improves the efficiency of trials. We have had measurements taken, so far as you can do this in a scientific way, of both the Great Southern class action before Justice Croft, which ran for about a year. Then we tested again with the Kilmore-East trial. Our research reveals that around a third of court time was saved by the use of technology. That leads me to indicate to you that technology and its application is the way of the future. We will see more and more of it. In the Supreme Court, we have set ourselves a goal to be a paper-free court by 1 January 2016. The clock is ticking, but we certainly hope to reach that goal. Building on the Kilmore-East experience, we have other class actions coming into the court. The Murrindindi bushfire trial will run next year, it seems, for the bulk of the year. We've had Great Southern, and there are both common law and commercial class actions coming in constantly. It is a challenging time, but an exciting time. Another reform which is about to happen very, very soon in the Supreme Court, on the 10th of November this year, the Court of Appeal will introduce the new civil appeal reforms. This will streamline the civil appeal processes in the Supreme Court, and we believe will dramatically reduce waiting time for appeals to come on. Effectively, in most cases, there will be no automatic right of appeal. Appeals will require leave, and in many cases, leave will be considered on the papers. There will be an opportunity for an election if a party wishes to be heard. But essentially, it will be a way of speeding up the whole process. Coincidentally with the Court of Appeal, we are aiming in most instances to set specialist appeal benches. So cases coming out of the commercial court which have been on a fast track will go into the Court of Appeal. And let me give you an example of an insolvency case that would have seated on the bench insolvency expert judges, for example, Justices Whelan, Justice Santamaria and Justice Ferguson, to give you an indication. If there is, for argument's sake, a planning or an environmental appeal, there will be other judges with that particular background. All part of expediting and smoothing out the path to ultimately achieve the resolution of litigation. Mediation, particularly court-annexed mediation, has become a significant phenomenon in the Supreme Court. The other day I was speaking to Associate Justice Wood, and he told me that he had just finished his 100th court-annexed mediation for the year. The availability of court-annexed mediation through the associate judges, such as Associate Justice Eftham, Wood, Gardner and others, is not available universally, but it is used very carefully and selectively. Many of you have been in cases where, for example, in the commercial court, the plaintiff's case has been opened, the defendant has provided its response, and at that time the trial judge has referred the matter off to court-annexed mediation. This has proved to be very, very effective and productive and of benefit to the parties. So there are a few snapshots. The President of the Law Institute mentioned the Mediation Centre, and I would select that as a highlight. We have had mediation facilities in Sydney for many years. Melbourne needed that facility as part of the national grid and the push to attract arbitration into this country. The next port of call may well be Perth, certainly if Chief Justice Martin has his way, and so we see a national grid developing which will utilise the skills of all the bars and the profession. Of course, Victoria has a very prominent arbitration bar and profession. We might expect to see many arbitrations here in Melbourne. So there's a snapshot of the sorts of things that are going on, short term, longer term. But I did want to speak to you this morning and give you some thoughts about the future direction of your role as a lawyer and the role of litigation in the future. If you think about your role, it is very much one where you have been educated, developed and practiced in an adversarial setting. And it is maybe time to start to think about a different way. If you think about the role of the lawyer in the courtroom and working for clients and applying the law, if you think about the role of the judge in administration of justice, and if you think about it this way, we are all in this together. We all have a different role to play, but we are in this together. Ultimately, what we want is the resolution of disputes. Your clients want speed, efficiency and economy. Perhaps something to think about this morning and through your discussions today is there another way to approach this which is less adversarial? What I would suggest to you is that what we do, what we engage in, ultimately is a contract between the bench and the profession, whereby we work cooperatively for the benefit of clients and in the interests of the administration of justice. It is a collaborative, cooperative exercise, a contract. Now, of course, in any contract, the obligations lie with the parties to that contract. So let me start with the judiciary, the bench. I would like to suggest to you some of the obligations that lie with us. In order to achieve the best resolution of disputes, judges must be prepared, be across the submissions. This allows a judge to adequately engage with counsel and supervise the case. A judge should be courteous, civil to counsel and the profession. While being courteous and civil, judges must also be firm in not allowing irrelevant points and arguments to be made. In addition to being courteous, judges should be good listeners, but they should be interactive listeners, not sit silently so that the parties can't calculate or analyse what it is the judge is thinking. The parties need to have some indications so that they can answer the judge's point. Importantly, and picking up on what I said at the beginning, judges need to be across technology and subsequent development. All the major law firms, all those with busy practices at the bar, you are very technology savvy. It behoves the judiciary to be able to respond to that savviness. Judges must commit to delivering judgments in a timely manner. They must keep in mind that parties are often in a state of limbo while waiting for handout. And of course, from the point of view of your clients, time costs money. Judgments should also be written in an accessible form. While arguments can be delivered in a very technical and legal way, the bench must keep in mind the fact that the ultimate consumer of what the judge writes is the client. It should be possible for clients to be given the judgment, even if it is a technical judgment, and be able to understand why they won or, importantly, why they lost. Judges should, as part of the contract, encourage the parties to work collaboratively in their interaction with the court. This means allowing parties to have input into timetables and the provision of documents. Now, while judges are specialists in adversarial justice, they should encourage the parties to engage in ADR. Now, that's the judiciary, and they are some suggestions. Let me turn to the bar. Counsel should be aware of their obligations under the Civil Procedure Act to facilitate the just, efficient, timely and cost-effective resolution of the real issues in dispute. Let me say this loudly and clearly. Counsel should not take unnecessary points. If you need a hint from the bench, it is one of the things that irritates judges the most. And of course, none of the counsel in the room would wish to irritate the bench. In addition to not taking unnecessary points, counsel should be wary to not be verbose. Succinct submissions are welcomed by the bench. Counsel should be courteous and civil to the bench, but also to their opposing counsel and to the other practitioners in the courtroom. This assists the parties in identifying the key issues and seeking to resolve them. Counsel should keep in mind not just their capacity when making submissions as to timelines, but they should understand the ability of their instructors to comply and to make appropriate submissions reflecting that. Counsel, along with their instructors, need to be open with their clients about the process. That sometimes will involve looking directly at the client, explaining to the client that, in accordance with the principles in the High Court, it is counsel who runs the case, not the client. It is challenging and difficult, but there are times when a client has to be told that a point cannot be taken, evidence cannot be led, or that where the weaknesses in the case are and what course the client should follow. But importantly, counsel should engage in collaboration with their instructors. Barristers too, as I have adverted to a number of times, should keep abreast of technological developments. And this has another benefit in that it pushes the bench. And it is a very healthy litigation scene if the bench is being pushed by counsel out front. Let me now turn to the lawyers, the practitioners. Similarly, they must be aware of the obligations under the Civil Procedure Act. They also need to be prepared for hearings. They need to know what is going on, to be on top of the brief in a different way, but as much as counsel. They need to have a cooperative attitude towards their opposing firm. It is so easy to become engaged in combat, even litigation warfare, and lose sight of the fact that ultimately what we are all engaging in here is the resolution of a dispute in a timely, cost-effective way and in a way that is satisfactory to the client. Most importantly, with the practitioners in the room, one of the themes that resonates constantly through judges, and I hear this all the time from the commercial court judges, is that counsel have not been briefed early enough in the case. Secondly, that delays in providing the brief to counsel have led to unnecessary and wasteful preparation. For example, pleadings. Pleading is an art. I do not suggest that lawyers, practitioners cannot draw pleadings, but it does need to be appreciated that there is a particular expertise at the bar, and for as long as we have pleadings, which we do in litigation, then it should be prepared by the artists, not by those who have strengths elsewhere. Practitioners also need to be honest and upfront with clients as part of the contract, as to timing, as to costs, and as to expectations, equally as with counsel. So they are some suggestions as to the obligations of the three main parties to the contract in litigation. Now you might say, well, that's all very well, but why cooperate? Well, there are the overarching obligations under the Civil Procedure Act. In Victoria, in the state courts, whether parties like it or not, they are subject to the Civil Procedure Act. And there are similar provisions across the Federal Court and the Supreme Court of New South Wales, and indeed the Supreme Court of Queensland. But what I would like to urge you to consider is that you do not do these things simply because you have to, but you would do them because it produces a better outcome for your client. Candour, courtesy and cooperation facilitate faster and less costly resolution of disputes. So let me give some suggestions to you as to how this cooperative, collaborative approach might look like. It manifests itself in various ways. Obviously, responding promptly to reasonable requests for information, obtaining joint appraisals from experts, conducting oneself in a reasonable, courteous and professional manner, even in trying times, using constructive problem-solving techniques to settle clients' disputes, urging constructive problem-solving techniques to assist the court, and indeed assist the court, conducting discovery by agreement and not using the discovery process to harass other lawyers or their clients or to generate unnecessary costs. Now, these are just a few suggestions, but all of you involved in litigation know the sorts of things that can be done to lead to a quicker path to the judge and to the determination and resolution of the dispute. Can I give you a couple of examples of how, very significant examples, how this cooperation has worked? Following the outcome of the decision in the Timbercore investment scheme class action, there are now around 1,600 cases which have to be individually determined. They are presently before Justice Judd. What His Honour has done is, last Friday in a directions hearing, prepare with the cooperation of the parties a template. And with the use of the template, and there are many, many lawyers involved in these cases, His Honour was able to conduct a directions hearing for about 150 separate pieces of litigation last Friday morning, and he finished the lot by about 11:30. This could only have been achieved by Justice Judd because of the approach that he took, the performance of his contractual obligations under the litigation contract, but importantly, because of the cooperation of the parties. Another example, again to revert back to the Kilmore East Black Saturday class action. Justice Forrest will talk about this at length later, but it was a large, high-stakes, hard-fought proceeding. The parties were very good at discussing the tendering of documents, agreeing which documents could and could not be tendered. Experts were able to focus on the issues in the dispute through the use of expert conclaves. There was cooperation within the court, with the trial judge being able to draw very effectively on the assistance of associate justices in managing the expert conclaves and the issues arising from it. So there are a couple of very quick examples. Without that cooperation, those cases would still be running. And we would need to reflect at the end of the day, if that had been the case, what would have been the cost to the community and who would have been the ultimate beneficiary? The client, the winner, the loser. These are reflections that we need to have. If we decline to have these reflections, then it's my view that we will face very, very serious challenges. We need to be alert to the fact that if we, as those engaged in the parties to the litigation contract, do not seize the moment and take the leadership, we are at risk that government will intervene. We have seen this already with the Civil Procedure Act, that it is a government-driven response, albeit supported by the courts and largely by the profession, but it has been governmental intervention to try to manage and control litigation. It is an adversarial setting that we live and breathe every day. What we need to do is to find ways to dilute, vary, and soften the impact of the adversarial setting. We might learn from the European experience, where judges very much control the litigation. Discovery is confined and directed by the judge. The scope of the evidence is directed by the judge. Litigants in person may be assisted by the judge and indeed mostly have to be. The imbalance in resources is eliminated between the parties. Cross-examination is directly controlled. There is no longer a need for lengthy judgments dealing with every single argument that the parties put forward. If we learn from the European experience, trials would be shorter and costs might be a fraction of what they are now. Litigation would no longer be used as a tactic, and class actions would be tightly controlled. As one of my colleagues suggested to me last night, it's time to say, why don't we talk about Kevin? So could I suggest to you, indeed encourage you in every way, to seize the moment of this unique collaborative opportunity where the bar and the profession meet, to ask yourselves the question, to ask each other the question, can I do what I am doing right now differently? I congratulate the Victorian Bar and the Law Institute for the initiative today. It is, as I say, a unique event and one that I hope will become an annual one. Thank you.
I now call upon Chief Justice of Allsop. Thank you.
Chief Justice, judicial and professional colleagues. I think the first thing that needs to be said today, given we're talking about high stakes, is that this country, I think, this nation, faces a challenge in the region to continue to be recognised for what it is. That is a country with a first-class legal profession, a first-class judiciary, and an imaginative and constructive approach to dispute resolution, in particular commercial dispute resolution. The challenge encompasses the roles of courts, the profession, arbitration, and dispute resolution generally. It should not be seen as a competition with Singapore or with Hong Kong, but as part of the development of the international reputation of the region as a whole and the major commercial centres of the region. And it is a challenge to be approached nationally. And it's an absolute prerequisite in that, meeting that challenge. And as a matter of national importance for the courts, the Supreme Courts and the Federal Court, is the superior courts of the country, to develop and invest in their procedures, and especially their procedures, both curial, arbitral, and annexed mediation procedures in commercial matters to deal with this challenge. And it's not putting it too highly to say that we have a vital national public interest in the Federation developing and maintaining first-class commercial dispute resolution systems, and within them as a core element for all types of ADR, arbitral, mediation, and the like, the central focus of first-class commercial courts. Let me describe two important developments in the Federal Court that will help facilitate this in the court of which I'm part. First of all, the introduction of electronic court file. Many of you will have experienced at least training in this. By early next year, the court will have an electronic information system and filing will be electronic. I won't go through the detail of it now. I wish to keep your interest. But it is important because what it does is it creates the electronic foundation for both the profession through the Commonwealth Courts portal, and hopefully in the next phase of it through password-based entry. The court file can be the file of the practitioner, as it is in United States district courts in the United States. But more importantly, for present purposes, it creates the foundation for the creation of, or the restructuring, I think I'm allowed to tell you, I'm not allowed to tell my colleagues, use that word, the reorganisation of the framework of the federal court into a truly national court framework. I'll be addressing this second development in more detail later this month in Melbourne, Sydney and Brisbane. Let me briefly, however, introduce it to you today. The framework will be facilitated by the ECF, the Electronic Court File, because it enables immediate, completely contemporaneous access to information of the court of filings anywhere in Australia, in multiple sites, as soon as a document is filed. And the change will be this, that while state registries will remain as administrative organs, the changes will see the whole of the court's work organised and managed nationally by reference to the significant subject matter areas of the court. So there'll be nine significant areas, 8 of them subject matter areas. First will be appeals, second will be administrative, constitutional and human rights, third will be native title, fourth will be industrial relations and labour law, fifth will be intellectual property, sixth will be taxation, seventh will be admiralty and maritime shipping, ninth will be criminal cartel trials, eighth will be cartel trials, and ninth will be commercial and company law, being a broad scope of work including commercial company insolvency, including bankruptcy, competition and international commercial arbitration. Judges will be assigned to those areas of practice. The changes will not require judges to travel significantly more than they do now, though it will enable the court to more readily utilise the talents of judges in one registry for the benefit of other registries. And the national practice areas will be managed fully nationally by judges responsible to me, and they will work with the assistance of a newly created position of a National Operations Registrar who will in effect oversee, from a registry point of view, the allocation of the work and the assessment of where the work is lying and where the work is being done. For instance, there will be, as I said, a national commercial and companies practice area with that broad spectrum of specialised and non-specialised commercial work, including regulator and consumer protection work. That being truly commercial because it sets the standards, as many of the cases in the court do, for the conduct of commercial activity in this country. The goals of the National Court Framework include, in effect, the establishment of a structure and a mode of operation that builds through those great subject matter areas of jurisdiction a truly national court with working within it 9 operating courts, from an appeal court to 8 subject matter area courts, including a national commercial court. I'll be outlining this in more detail in Melbourne on the 27th of October. The timing of the full implementation of the changes will be March, April next year, with the full implementation of all the bells and whistles of the electronic court file. But there will be a phasing in over the next few months, and I would anticipate that by mid-November there will be an operating commercial and company court in the eastern seaboard in Brisbane, Sydney and Melbourne. An integral aspect of the new arrangement will be management of appeals, including case management where necessary, both in a coherent appellate structure and in a manner that's integrated with the management of the first instance subject areas. This will be achieved by examination of every appellate matter upon filing by the judges managing those appeals and evaluating the need for and delivering case management or expedition. This is what I've been doing this year myself, putting in place that system of examination of every filing as soon as it comes in and requiring case management where necessary in the same, same manner that I did in the New South Wales Court of Appeal when I was president there. All commercial matters, as they should, if they've been given a form of expedition, given a deemed expedition. And the close integration of the appeal work of the court with the various national practice areas will be achieved through the cooperation and discussion between the judges responsible for those practice areas and the judges responsible for running what is in effect the appeal court. To the extent that urgent appeals, including commercial appeals, can be heard between full court sittings, they will be, and this will shorten what already is a tolerably short usual wait of about 6 months to a shorter period. The new arrangement also will be a catalyst, I hope, for a significant re-examination of case management in the court. As the Chief Justice said, we do need to talk about Kevin, I think. It's a good way of putting it, if I may respectfully say so. We have a problem about costs. Case management can reduce costs and generally does when it's done well, or always does when it's done well. But it can exacerbate them if it's done badly. If it's done badly by an unthinking and process-driven methodology. There's a real need for the courts and the profession to revitalise the place of case management and the efficient and cost-effective resolution of cases. It requires thoughtfulness, cooperation, and a rejection of process-driven costs. Is it the fault of the courts? Well, perhaps, to a point. I'm prepared to accept that detailed, long practice notes that are process-driven, automated sequential steps that are required to be done before thinking begins is a problem. And it may be a problem that we as courts have done by continuing to impose as opposed to listen and engage. But is it only the court's fault? I don't think so. I think we all need to examine how we work, how we think about cases, how we cooperate about them, and how we reduce what we do to essentials. No one minds paying for skill. Everyone minds paying for process. And there will be a renewed emphasis, I hope, in the court on the efficient and thoughtful commercial preparation of cases by both the profession and, to the extent that the court's involved in that preparation, by the court. It's a real challenge for us, I think. It's a challenge for you, and it's a challenge for us judges. We will see costs relatively reduce if there's constructive engagement based on thoughtful and imaginative approaches to litigation. And a conscious rejection of process for its own sake. And if we do that, this country and the great centres of litigation in it will enhance the reputation they have for being the best profession and the best courts in the region. It's a challenge for us, because if we don't do that, I think this conference in 20 years' time will be populated differently. Thank you.
Can I just ask the people at the back, would you like to come in? There's a number of seats up the front, please. Please come in and join us. We have a few moments for some questions of either of the Chief Justices. Do I have any questions? Michael.
And thirdly, the high stakes and complexity which attends many group proceedings. How do the courts propose to examine other ways in which complex group proceedings might be settled earlier? Speaking for myself, the main problem is the quantification of claims at an early stage.
Thank you, Mr. Wheelahan, for the question about class actions and how to effectively and even better achieve settlement. In terms of quantification of claims, judicial involvement early is highly desirable, with the judge encouraging the parties to engage with their experts, to try to achieve the conclaves, to get the experts together, and also to have a suitable mediator selected to work with the parties right possibly from the very beginning, not to leave it until people have become entrenched in their positions, but again to facilitate and encourage parties to try to refine the case and identify the issues, and encourage the parties to work with the experts, but also the mediator, where appropriate, to work with the experts. The second matter, the question of multiple parties. The whole class action scenario is one in which we are constantly learning. They are still very, very novel for the courts, even though we've now had a number of them, both state and federal. Coming out of the Kilmore East class action, there has been so much experience drawn, and before that, Justice Forrest was able to draw on the experience of Justice Croft in Great Southern, and certainly Justice Forrest, before he started Kilmore East, conferred with Justice Gordon about her experience in the Centro class action. So the judiciary is constantly learning and building from the experience. I would expect logically the litigators across the room are doing the same thing, and it may be the multiple party approach and indeed the quantification, all of those things can be managed better. As for the high stakes, well, that's what class actions are really about, and as long as it involves the large corporations and the government sector, the stakes are high, and it's very much, it seems to me from what I have seen, a take no prisoners approach. Now, if we can try to ameliorate that approach early by having the mediator in from the very beginning and use every ADR tool available to the judge, referees, mediation, all of those things, then we will gradually progress this further. But it is an ongoing learning experience.
May I endorse those comments? The dual operation of mediation on a parallel but separated track, obviously, I think is fundamental. And we were taught, I mean, I'm sure Chief Justice Warren would experience it the same. I mean, when I was a barrister, I was taught very early, the first thing you work out in a case is what it's worth. And I think people I think because of the scale of the cases, people are forgetting that pretty fundamental. Now, it's hard to work it out, I appreciate it, but people have to try, and I think the mediation, the parallel use of mediation and a creative, thoughtful use of assessors and referees and the like would be very helpful. But may I add, without the slightest hint of criticism, the question rather throws up the point I was making last in my speech. What are the courts going to do about it? Okay, what are you going to do about it? It is for us to think about how we work our institutions most efficiently in the public interest. But it's also for you as the profession to think creatively about what you bring to the court, to engage with the court in this is how we think this can work. And one of the problems is working out what this case is worth, and we suggest we mediate, or we use this technique, or we perhaps something goes out to a referee immediately for a referee's report so that we can better understand how the rest of the case should run. So I think we all need to engage a bit better with how we think about our cases.
Do we have any further questions? Can I say on behalf of all of us, we're truly thankful to both our keynote speakers, Chief Justice Warren and Chief Justice Allsop. It's marvellous to have an indication of the developments in the courts, the efficiencies of the courts and the aims and goals of the courts. I think it's even more important to be challenged in our profession to ensure that at least our part of the contract as a profession is properly adhered to, and we look at new steps and ways to have more cost-effective litigation, whether it be by further steps of dispute resolution, whether it be by briefing barristers earlier in litigation. On behalf of all of you, can I thank both Chief Justice Warren and Chief Justice Allsop on two marvellous presentations, and thank them very much for attending.